I give the floor now to Dr. Gabija Grigati-Daugirda for Lithuania. You have the floor, madam.
Good afternoon. Madam President, members of the court, it is an honor to appear before you as agent of the Republic of Lithuania in this important case. Previously, Lithuania took part in 2 cases and 1 advisory proceeding before the Permanent Court of International Justice. Soon after, it was illegally annexed by the Soviet Union for nearly half a century. Of injustice, and since resuming independence, Lithuania has always relied on international law to sustain its existence and freedom. And it consistently objected to the alternative international law narrative created by the Soviet Union and later by the Russian Federation. Today, for the same reasons and in quite reminiscent circumstances, Lithuania stands for the respect of the territorial integrity of a fellow sovereign state and against the blatant disregard of international law by the respondent under false pretext based on the Genocide Convention that formed the gist of this case. Today's hearings is dedicated to the court's jurisdiction under Article 9 of the Convention, and I have 2 points to make about the construction of that provision. My first point concerns the type of disputes that fall within the ambit of Article 9. My second point concerns the court jurisdiction ratione materia, that is, the claims that the court may entertain pursuant to that provision. I turn to my first point regarding the types of disputes that fall within Article 9. Members of the court, it is an undisputed proposition that Article 9 must be read in the context of the other provisions of the Convention. In this regard, contrasting Articles 8 and 9, the court held last year that, I quote, Article 9 provides the conditions for recourse to the principal judicial organ of the United Nations in the context of a dispute between contracting parties, whereas Article 8 allows any contracting party to appeal to other competent organs of the United Nations, even in the absence of a dispute with another contracting party. End of quote. Moreover, as the text of Article 8 makes clear, it is solely concerns, I quote, the prevention and suppression of acts of genocide or any of other acts enumerated in Article 3. End of quote. In contrast, disputes falling under Article 9 are not limited to the prevention and suppression of acts of genocide, but may more broadly, I quote Article 9, relate to the interpretation, application, or fulfillment of the present Convention, including those relating to the responsibility of the state for genocide or for any of the other acts enumerated in Article 3. And as the court also previously made clear, disputes relating to the responsibility of contracting parties for genocide are comprised within a broader group of disputes relating to the interpretation, application, or fulfillment of the Convention. Wherefore, the functional and textual differences between Article 8 and 9, that is, the distinct areas of application, indicate that disputes stemming from allegations of acts of genocide may be submitted to the court for adjudication, even if the claims submitted to the court by the applicant do not concern the perpetration of acts of genocide by the respondent. In other words, the court's jurisdiction under Article 9 extends here to disputes resulting from the contestation by the applicant of allegations by the respondent that acts of genocide occurred or were about to occur on the territory of the applicant. Lithuania considers that when a state accuses another state of committing genocide and that another state rejects such accusations, a dispute exists under Article 9 of the Convention. This includes instances in which the accusation of genocide is made with a view to justifying acts allegedly preventing genocide, which may, at the same time, engage other rules of international law. This construction of Article 9 is confirmed by 2 of its textual elements on which other intervening states rightly insist. First, under Article 9, a dispute can arise about the fulfillment of the Convention. This means that when one state protests against another state's allegations that genocide is occurring or about to occur, such contestation gives rise to a dispute about the fulfillment of obligations under the Convention. And secondly, Article 9 explicitly states that the season of the court can be the initiative of any of the parties to the dispute. Accordingly, such a dispute can be submitted to the court by either of the disputing states. To sum up on this first point, a state party that considers itself falsely accused of genocide by another state party may rebut such an accusation and submit the ensuing dispute to the court pursuant to Article 9. Lithuania submits that this construction of Article 9 entirely conforms with the terms and is also consonant with the higher purposes of the Convention and the preservation of its integrity. Madam President, members of the Court, I now turn to my second point, which concerns your jurisdiction ratione materia under the Convention. A state that considers itself falsely accused of genocide may notably claim that such accusation is the result of the breach of Article 1 of the Convention and that the actions undertaken for the alleged purpose of preventing the perpetrated genocide are likewise wrongful under the Convention. As Lithuania has set out in its Declaration of Intervention, the question of whether a party has fulfilled its obligations under the Convention may be particularly salient in relation to the obligation of due diligence entailed by Article 1, that is, to collect substantial evidence from independent sources that acts of genocidal nature are being perpetrated before undertaking any preventive action pursuant to the same provision. Such a claim falls within the jurisdiction ratione materia of the Court under Article 9 of the Convention. Whether Article 1 entails an obligation of due diligence to collect substantial evidence before engaging in the prevention of an alleged genocide is a question of interpretation of a convention that falls unquestionably within the court's jurisdiction. And we further submit that such a question of interpretation would fall to be determined during the merits of this case, because Article 1 is not a provision that defines the scope of a treaty. Lithuania further recalls that, as the court already made clear, the means by which an international obligation is allegedly breached are irrelevant for jurisdictional purposes. The nature of the means by which the respondent wrongly fulfilled the obligation to prevent genocide under Article 1 are thus entirely irrelevant at this stage of the proceedings and do not concern your jurisdiction ratione materia. This being said, the court jurisdiction under Article 9 undoubtedly extends to disputes over the measures taken purportedly to prevent genocide pursuant to Article 1. Finally, Lithuania recalls that when the court has jurisdiction under Article 9, such jurisdiction also extends to applying the rules of general international law on treaty interpretation and on responsibility of states for internationally wrongful acts. Lithuania respectfully submits that the court's jurisdiction extends for the same purpose to applying other rules of treaty law, in particular the one concerning the obligation to perform treaties in good faith, when they are pertinent, of course, to the dispute at hand. Wherefore, claims concerning the breach of such obligations necessarily fall within the court's jurisdiction. This is all the more the case in relation to Article 1 of the Convention, because under that provision, the contracting parties solemnly undertake to prevent and punish genocide. Thus, under the Convention itself, the contracting parties are bound to perform such obligation in good faith. Madam President, members of the court, I thank you for your kind attention. I also take this opportunity to thank my legal counsels, Professors Pierre Darjon, Glyde Hernandez, Inga Martincute, and Christian Tams, for their assistance in preparing Lithuania's submissions. Finally, I also express our gratitude to the Registrar, his staff, and the court's interpreters for their professional and courteous assistance. Thank you, Madam President.
I thank Ms. Grigate Daugirde, and I invite